So the Supreme Court has said that they will not hear the appeal regarding the E. Jean Carroll case with President Trump, which isn't a case that I've honestly followed a whole lot anyhow. Just, who follows the news that hasn't at least heard about it a little bit. But what stood out to me is the way news reporters were handling this today. And so I want to talk about that. So welcome to Whatsoever More or Less. My name is Jason, and I am just a student of the Constitution by way of years of studying commentary and then the Constitution a lot itself, commentary from the founders, etc. So let's look and see what people thought in the news was the general idea. They thought that the courts should be dealing with defining the supreme law of the land, whether it was right-wing news that I was listening to or left-wing news. That was kind of the consistent message I got, was they think that the courts need to be spending more time defining our Constitution for us. And I'm just going to say right now, that's an insane idea. When you read the actual Constitution itself, nothing allows for that. Not in Article 3, not in Article 6. Article 2 does not tell the president he needs to answer to the courts. The courts are to resolve cases, to limit themselves to resolving the cases in law and equity arising under the Constitution, the laws, and the treaties. Okay, this is the judicial power of the United States. Then, if it's being appealed, the Supreme Court may review the law and the facts, right, regarding the case and deal with the appeal. That's what needed to happen with the E. Jean Carroll case. And it's a high-profile case. It's a big deal, right? This is a big one. We don't need the Constitution redefined for us. As a matter of fact, Thomas Jefferson in 1820, a friend of his was telling him about the Alexander Hamilton, I think, stance. I don't know the whole details of all the conversation that was going on in these letters back and forth between Jefferson and his friend. But basically, he brings up what Hamilton said in Federalist number 78, if I'm not mistaken, and the idea that the Constitution is defined for us then by the Supreme Court decisions. Now, he's saying this to the same man who's responsible for writing, governments derive their just powers from the consent of the governed, not from the interpretations of the courts. How can the governed give their consent to something that wasn't written down and presented for the ratification process? They can't. And so it's not just powers. I don't care. The oath of office is to the Constitution itself. If you're a lower level judge underneath the Supreme Court judges, what about the Constitution justifies even the Supreme Court telling you that your decisions need to mirror their decisions? If their decisions are incompetent decisions, your obligation is to point that out. Nothing more, nothing less. Read Article 6, Clause 3, right? So, we have got this idea, especially since 1925, the Judges Act as it's called, or the Judiciary Act, which was, I think, the last eagle head to be put in place right before Herbert Hoover became the first feather in Ezra's eagle, right? So Herbert Hoover was elected basically 3 years later, right? So the Judges Act basically, former President Taft was the Supreme Court Chief Justice, said, hey, we need to be redefining the Constitution for everybody. And they were putting in judges that were hardcore on this idea. Hey, the Supreme Court's going to be redefining the Constitution for everybody, right? And so the idea was the court wasn't supposed to be taking regular cases a whole lot anymore. They're typical types of cases. They were supposed to instead be confining themselves to redefining the Constitution for us wherever there was controversies. I think this, along with the 14th Amendment, if you can get those two things to go away, you might bring us back to a fairly normal Supreme Court. But even prior to that, who was it? Polk, I want to say, Buchanan, one of those guys had this ingenious idea that leads to the Dred Scott thing, right? Hey, we're going to use the courts and their courts' opinions to redefine the Constitution so everybody shuts up and we've got a constitutional answer. Look, the fruits of this whole idea are terrible fruits. You get the Civil War shortly afterwards. We need to stop. President Oaks really argues for us backing off of using the courts to redefine the Constitution for us so much. I recommend looking at his University of Virginia lecture that he gave. I recommend looking at his talk that he gave in Utah called Fundamentals of Our Constitutions. And even just the quick little jab that he puts in defending our divinely inspired Constitution. About inspired amendments, however, we do not find inspiration in the court rulings. It's impossible to find inspiration in the court rulings because, our doctrine is whatsoever more or less comes of evil. And the Constitution doesn't allow for the court redefining the Constitution. You just can't find evidence of it. That's why Jefferson flatly rejected it. Plus, he said it was an unwise policy. But to top it off, there was no evidence in the Constitution that the people had given their consent to this concept. And if we haven't given our consent to it, it's not there. It's not real. So, an actual case that would have been useful to resolve in appeal was rejected. And instead, we're going to have the courts tinkering around again with the 14th Amendment, like they do at least 1/3 of the year, pretty much. They're always tinkering around with something about the due process. And oh my gosh, dudes. That thing really needs to... by its fruits, you'll know it. The 14th Amendment was an unwise amendment, if you ask me. But, I keep hunting for that clause that allows for the government to coerce the states into remaining in the Union, and then coerce people to ratify amendments before they can be seated in Congress. Oh yeah, that's not in the Constitution. It's not allowed. And Joseph Smith, when he ran for president, it's real interesting when you look at his statements regarding annexing Texas, Canada, the Western territories where the Indians were. Consistently, his statement was, if they want to, if they're willing to, and they ask to be admitted, we should annex them. If they don't ask for it, we'll let them be. And you should really look up his quotes, too, about what he said, even regarding the relationship between the abolitionists and the Southerners back in the 1830s. So right is right, wrong is wrong. We can all be honest about that. But our Constitution, our nature of government, doesn't allow for one group of people to force everything to be just right. It allows for a lot of individual agency, and when you've got someone constantly redefining the Constitution, that takes away a lot of agency. It amends the Constitution for all intents and purposes without actually amending the Constitution, and that's just because the way we keep treating it by way of tradition. It's a part of the secret combination. The three heads of the secret combination are the international entangling alliances or treaties that exercise powers they're not supposed to exercise. Then the technocratic administrative state, the administrative agencies, expert agencies, whatever you want to call it, and then the judicial supremacy, the idea that the Constitution is redefined. More of our governance comes from these three things than it does from the original three branches by a long shot. And what I would call the additional three branches that actually are in the Constitution, the three branches of responsibility, the states, the officers of government, and we the people, they've abdicated their duty. And so we're in a situation similar to the Book of Mormon, where we hear the more part of the righteous upheld the secret combinations. I think that there are a lot of good members of the church that do a lot of good things. They're the kind of people that go and do their home teaching, their callings, all that kind of stuff. And they are just convinced that, that's all they got to do, and the Lord will protect them. But how many times do we have to be exhorted to actually study the Constitution, learn to recognize when laws are constitutionally unsound, to develop that talent? There's nothing in the Book of Mormon that implies that supporting the secret combinations is an act of righteousness. It just means the righteous got seduced by this idea that it was a good idea. That's all. That's it. So this E. Jean Carroll case, to me, what it represents is the courts flip-flopping the main priorities that they were originally set up for. They were originally set up to actually resolve serious, important cases. Immigration should have been left in the hands of the Congress. Anyone who can read that first section of the 14th Amendment can tell that it's present tense in its layout, not future tense, which is an anomaly completely different from the rest of the Constitution, when it's shall be this, shall do that, right? But I think it was unwise to even make the 14th Amendment in the first place, right? The 14th Amendment stands out like a sore thumb compared to the 13th and 15th Amendment. It's not a normal amendment. And again, even the 13th and the 15th, I don't know how we're going to remedy the fact of the way those things were coercively ratified and what have you. We can be looking back at the past. Some people may say, looking back at the past, what do we get out of doing that? Dudes, what in the heck does government do if not constantly look back at the past and then try to fix it? Duh. This is like the most obvious thing in the world. If somebody's going to a trial for something, right? What are they going to trial for? Something that happened in the past. So anyone who says it's not useful to look back at the past, well then shoot, why don't you just forgive anybody who's accused of anything? Doesn't make sense. Okay? Well, there's my thought. Thanks for listening. See you.